What you're about to hear is Judge Meyer's shocking statement. Listen closely.
Mr. Evans, trials are not about truth.
Did you hear that? Trials are not about truth. Listen again.
Mr. Evans, trials are not about truth.
You just heard it again, in a courtroom on the record, that trial is not about truth. In part 1, we asked what that really means. In part 2, we're going to show you. At issue is the defense's ability to establish its case. The focus is an internal affairs report from the Tempe Police Department's Professional Standards Bureau, documenting serious systemic failures in evidence collection, testing, preservation, contamination, destruction, and chain of custody. You'll hear Judge Myers state that the defense will not be allowed to use that report to smear the police. So the question becomes, is the role of the court to protect the reputation of the police or to allow the jury to evaluate the evidence? Let's listen.
All right, so my understanding is that the state does not intend to offer any evidence that came out of the Tempe Forensic Services Unit. Is that correct?
So the investigation involved fingerprints and issues within that department with regard to fingerprint testing. That's what the internal investigation was involving. The letter that the defendant wrote that the state has stated is self-serving hearsay and therefore not admissible by anybody except possibly the state. Tempe did a print analysis on that letter, and then this investigation came to light, and in an abundance of caution, that letter was sent out to another lab with all the envelopes. There were 2 copies of the letter in envelopes, and another lab conducted, I believe it's Mesa, conducted a whole secondary testing of that letter. We are not planning on introducing the letter, so the fingerprint of defendants that was found on the letter is really not even relevant, but should the letter somehow become relevant, we would use Mesa's fingerprint people to establish that the defendant's fingerprint was on the letter, not Tempe's.
Okay.
So Tempe lab criminologists are not testifying in this case.
Yes, they are.
And as a matter of fact, the criminologist that was involved, Miss Shoemaker, was terminated or voluntarily left. I don't know. She resigned. She will no longer cooperate with anybody in the case, and we are not calling her as a witness.
Who is Shoemaker?
Yeah, and so there's no reason for the investigation of her or anything to do with that fingerprint to come in. There are crime scene technicians who went to the scene and took photos. That has nothing to do with this internal investigation.
What?
Okay. Okay, so Mr. Evans, what is it that you believe is admissible regarding the Tempe Forensic Services investigation?
Okay, first off, that was an absolute lie. So there was a scandal at Tempe. This internal affairs investigation went into, during the time that my case was processed, went into forensic malfeasance. There was improper evidence collection, storage. There was destruction of evidence, which is evident in this case. My police procedures expert is here today actually reviewed that and wrote a report on it. Okay, and there was another police procedures expert who couldn't testify before him, Roger Clark, who also wrote a report as well. So, and that is thoroughly reflected in this case. There are various reports that I have submitted of reports that were done by the they're Tempe Police Professional Standards Bureau that's shown during the time that these cases were processed, these people who went to collect evidence in my case and other crime scenes, they didn't have training to do this. These people were these people. So this goes for my evidence spoliation defense that I'm raising, which is admissible. It's allowed in Arizona, evidence spoliation. And the evidence spoliation had to do with the intentional destruction of evidence, which we have significant proof that there was destroyed evidence. The evidence spoliation also has to do with significant, the failure to test evidence and the failure to seize evidence when it was available for seizure. It has to do with breaks in the chain of custody, which has been established in this case. There are significant gaps in the chain of custody, which goes to the weight of evidence, which is part of the spoliation defense. And what I explain in my response that you have either had before you or have already read that some of the defenses are insufficiency of evidence, evidence spoliation, and improper police investigation. So that internal affairs report goes to that improper police investigation because what it shows is a culture. It shows a deep-rooted culture that government had found. This is the government's own records. It's way more extensive than just fingerprints. It is what happened was horrific in this case. case. And what the government found, and the government even sustained the findings that during this time, these practices were happening, and it was horrific.
Let's pause to recap what you just heard. Prosecution argued that the internal affairs report was limited to forensic fingerprint analysis, and because they were not introducing the fingerprinted letter, the report had no relevance to this case. But that's not what the report is, and it's not what it documents. This report was conducted by the Tempe Police Department's Professional Standards Bureau, the unit responsible for investigating misconduct within the department, and the report goes far beyond fingerprint analysis. It documents issues with evidence collection, evidence storage, destruction of evidence, failures to test and preserve evidence, breaks in the chain of custody, and broader forensic handling practices. This is not a narrow fingerprint issue. This is about how evidence was handled, and these same types of issues have been identified in this case. Because for the defense, this is not about a single mistake. In this case, it goes to whether these issues reflect a pattern, a practice, or a broader culture of how evidence was handled. And that matters, because it speaks directly to whether the investigation itself can be relied upon, in this case, in light of expert testimony. So the question is, does the court consider the expert findings? Let's listen to what Judge Myers says.
Multiple people had to resign because of what is shown in this report. So I need to bring this into trial to use it to lay foundation for my defense, evidence spoliation, because a lot of these malpractices and a lot of this misconduct is evident in my case. And again, we have...
If officers or crime scene technicians mishandled your evidence or destroyed your evidence, you will absolutely be able to question them about that. What does the report have to do with how they handled your evidence?
Because the report is rebuttal. It is rebuttal evidence to their arguments. Their arguments throughout this entire prosecution was that this was a reliable investigation, and it was not. They have argued that this was a open and shut, closed investigation where everything was properly done. The entire investigation reeks of misconduct. It reeks of improper practice, improper procedures. The report it's one thing, like let's say this for example. It would be one thing if I was to like go at trial and start to bring up some of these issues, right? Obviously the jury, or obviously people are gonna be like, okay, well, what is that? What does this have to do? Maybe this was just a one-time thing, or maybe this was a two-time thing. What does this really have to do with your evidence spoliation defense? But when you introduce this report and see how much employees were complaining about this, that were in Tempe, who were complaining about this, and you start to see how bad it was, so bad that Mesa Police did joint work with Tempe, and Mesa Police noticed how terrible what Tempe was doing, and they noticed they were using improper tools and to collect evidence. And Mesa Police made a complaint, and they complained about it. So I have an inability to reconstruct the crime scene in my case, to reenact the events of the incident for the jury. Okay, I also have an inability to reconstruct the crime scene because there was a secondary altercation that occurred after I left. And there's significant evidence of that. And I don't have the ability to show, and this is primary for my Willits instructions, I don't have the ability to show that how the secondary altercation occurred because of their lack of scene documentation. And I will not be able to sustain my evidence spoliation defense and to get my Willits instructions, which we're filing the Willits motion today. It's going to be filed today, but I'm not going to be able to get these Willits instructions without that internal affairs report. And I'm going to be prejudiced at trial. And again, if you remember, I don't know if you remember, but I was waiting for Deborah Stonebarger's report to be able to move for the Willits. We have the report. We disclosed it yesterday. And so I need this internal affairs report to not be precluded, because it's going to lay foundation for my police procedures experts testimony, my criminalist testimony, my Deborah Stonebarger, Timothy Scanlon, he's a forensic expert, is going to lay foundation for his testimony. It's going to lay foundation for Brian Neumeister's testimony, who's our data expert, who's seen that there is evidence that I just recently filed his report. There are photographs that have been destroyed. There are also photographs that's data have been altered. It's not the original data. So we have tampering with evidence in this case. Now that's pretty freaking significant,
Everything you're telling me you can do, none of it has anything to do with this report.
It absolutely does. It has everything to do with the report. Shows...
I understand that that's your opinion, but I'm listening to everything you're saying. saying you can talk about training, you can talk about handling of evidence, you can talk about destruction of evidence, you can talk about failure to impound evidence, you can talk about the police procedures. None of that has anything to do with the report other than trying to smear the members of the Tempe Police Department with a report that is out there.
Did you hear that? Judge Myers stated, none of that has anything to do with the report, other than trying to smear the members of the Tempe Police Department with a report that is out there. A report that is already out there? Which brings us to the question, how does referencing what is already publicly documented become smearing? Is it the role of the court to protect the reputation of the police department? Or is the court's role to allow truth to be revealed? We heard the prosecution reduce this report to a fingerprint issue, a clear omission of its actual scope. In response, the defendant laid out something entirely different, supported by 4 expert witness reports, a data recovery and photographic expert, a forensic criminalist, a crime scene reconstruction expert, a police procedures expert. Based on these findings, Sterling is describing documented evidence tampering, destruction of photographic evidence, altered forensic data, failures in documentation and preservation, and an inability to reconstruct the crime scene. And at the time of this argument, a police procedures expert is present in the courtroom, prepared to testify. All of this is before the court. And yet, the weight of these issues is not reflected in how Judge Myers characterizes the report, which brings us back to the question, is the court's role to shape the truth or reveal it? Let's listen.
And the question is the report admissible? Does the probative value outweigh the danger of unfair prejudice?
It absolutely
I'm going
does.
to grant the motion to preclude evidence of the Tempe Forensic Services Unit internal investigation.
I object.
Mr. Evans,
I object.
again, your objection to my ruling doesn't mean anything, but if something happens at trial and you believe something has changed, which now makes it admissible, you can address that outside the presence of the jury with the court. You can let me know what has changed and why you now need to be able to get into the report. But based on your arguments and what I've read, the motion is granted.
So one of the things I didn't get to tell you was that Laura Summershoe is being called to trial. Laura Summershoe is going to be called to trial. I can't cross-examine her on the report. She's the one who deleted and destroyed evidence in this case. She had to resign because of it. I have the right to cross-examine her on the report. Okay, then Lieutenant John Thompson is also coming to trial. He had to resign as well. I'm going to cross-examine him on the report. Frank Medina, he's coming to trial. I have a right to cross-examine him on the report. Not only that, but you determined back on the 22nd of October 2024, you determined that I would be able to cross-examine the jury on this report and on these issues at trial. When you decided to deny me the opportunity to get the Department of Public Safety's records on audits of Tempe, you said the correct thing for you to do is to cross-examine this during trial. Now you're contradicting that ruling. So this is becoming a real problem right now because you told me then that I can do this at trial. Now you're telling me I cannot. And the FTR captures your ruling where you said that. So I'm going to have to object. I need this report. I need this report for to cross-examine these witnesses on, to lay this foundation. I need it. And it's just, you're going against your prior ruling.
All right, next.
Here, the judge deliberately, improperly, and arbitrarily excluded this relevant report as defense evidence from trial. This report helps establish the government's intentional destruction of favorable evidence to me, such as crime photographs, and evidence that is possibly favorable to me as well. Furthermore, this internal affairs report establishes the government's culture of reckless destruction of intrinsic forensic evidence necessary to establish the true events of the incident at trial, harming any accused person who must defend themselves against accusations endorsed or sponsored by this corrupt police department. The internal affairs report pertained to egregious or otherwise horrific misconduct and forensic malpractice by police in all criminal cases, which are evident in my case as established by various expert reports and analysis. Some of the findings the internal affairs report sustained are improper collection, handling, packaging, and storage of evidence, no scene documentation procedure, a lack of employee training and proficiency testing in the field of forensics, damaged and unmaintened crime scene tech used in investigations, damaged crime lab tech used in analyzing evidence, expired chemicals police used to process crime scenes, intentional destruction of crime photographs, and employees who lack qualifications, experience, and educations working crime scenes in the field of forensics. There are critical constitutional violations and issues in my case that I cannot cross-examine police on at trial to substitute for the court's refusal to give me an evidence hearing into these issues for my motion to dismiss, wherein the court denied my motion to dismiss without even providing me a proper oral argument. I cannot cross-examine police on these issues at trial because the state is using the judge improperly improper ruling precluding this report from trial, to bar our questions or limit our questions of police personnel, while the state simultaneously elicits testimony that the police were justified in the destruction of the crime scene, which are not true. And despite the judge's guarantees that I could question officers on their misconduct or failures in this case, I am being limited from doing so, and am being restricted from objecting when necessary while the state is eliciting this false testimony. These actions by the court and state affect my ability to present a complete defense, while simultaneously affecting my ability to preserve issues during trial for appeal purposes. For arbitrary exclusion of relevant defense evidence, see Holmes versus South Carolina, 547 U.S. 319 126 S.CT. 1727 164 L.ED.2D 503 year 2006. For spoliation defense, see Allstate Texas Lloyd versus McKinney, 964 F.SUPP.2D 678 year 2013. I have been limited from making any record that shows that the police have violated my constitutional rights.
The law is clear. A defendant has the right to present a complete defense, and courts cannot exclude relevant evidence without raising serious constitutional concerns under U.S. Supreme Court, Holmes versus South Carolina, 547 U.S. 319, 2006. And when evidence is destroyed or altered, it is recognized as spoliation, a violation that demands scrutiny and consequences. But here, those issues were never fully examined. In Part 3, you'll hear what happens when those issues are challenged, and the court responds with a statement that changes everything. Trial is not about truth. Thank you for watching. If transparency in the justice system matters to you, like, share, and subscribe.